Good morning, everyone, and welcome to our People Matter webinar for the higher education sector. Today we're looking at effective performance management, and by way of introduction, am Samantha Love. I'm a Principal Associate in our team at Mills and Reeve, and Abisola Latunji-Cockbill is joining me. She is also a Principal Associate in the team. Today we are as I say, talking through effective performance management. But before we start, I will have some very brief housekeeping notes. Firstly, the recording of today's session will be available afterwards if you would like to listen to any part again or to join to send a copy to your team members. And we're also going to send a feedback survey. We would be really grateful for your feedback to make sure that we are tailoring these sessions to the content and style that works best for you. So on today's agenda, we are going to walk through 4 key areas and key considerations: dealing with barriers to performance, supporting managers, and the more nuts and bolts of addressing performance and how to work through a management process. But before we do that, I'm going to take one step back and ask the question, why does managing performance matter? And we're aware that you and your teams and the operational teams that you work with will be very aware of this, but it's worth bearing it in mind. We've put a number of different reasons on the slide, and I think in some ways a lot of it boils down to the same thing, which is we probably all have seen at least secondhand the impact on a team if there is someone with a performance related concern that's not being addressed appropriately. And as we'll come on to discuss, there are different ways of appropriately addressing a performance concern depending on what's creating it. But it can have a real impact not only on that single individual and their output, but on the team as a whole, including their manager as well as their peers. So the reverse of that is making sure that we're addressing those performance concerns appropriately can have a really positive impact. And from a legal perspective, you'll note the item at the bottom about changes coming in the Employment Rights Bill. Now, when those changes do come into force, the current position, which is that dismissing for a performance-related reason prior to 2 years service, can be lower risk at the moment because of the fact that the employee often won't be able to bring an unfair dismissal claim. That position is going to change, and that there will be a right to bring a claim for unfair dismissal from day one of employment, albeit we're expecting there to be an initial probationary period, probably of 9 months, during which there will be lighter touch obligations for dismissing for performance-related reasons. So actually, from a good management perspective and being aware of the changes that are coming down the track, it's also important that we're thinking carefully now about dealing with performance issues in the right way from that legal risk perspective. So moving on and thinking about the benefits of addressing performance early, that there is always this perception that performance management is simply the precursor to dismissing somebody. That's really not true in reality. Early addressing of issues and in the right way and sensitively can really result in team members having a much better performance in future, and of course lessens the burden for everybody involved of actually going through a formal procedure. So thinking about that and moving on now to address how we go around thinking about performance management, I'm going to start just by drawing attention to probationary periods. And I know that in the higher education sector, these can look quite different, especially for academic staff. But what I think is really important during probation is not only that all-important meeting or report at the end of the process, it's thinking throughout probation about making sure that you're having a two-way dialogue with a new team member to understand how they're settling into the role, whether they have everything that they need, whether they understand what's expected of them, and whether you feel that they're performing to the standard that can reasonably be expected at this point in their employment in the team. It's a really good way of making sure that somebody isn't blindsided by a probation report at the end of the process, that any concerns that arise are addressed. As we've put on the slide, it may be a lower dismissal risk if you're dismissing for performance during probation, because you've identified a problem and you're dealing with it early. But it is equally the right time to be dealing with it in a way that means you don't need to be thinking about dismissal. A really key part of this is the organisation's culture and the way that you address probation, and making sure that you're having those conversations with management and understanding that probation is not something that you simply pass or fail at the end of the process is a really key part of this, and we'll talk about that a little bit later. The concepts that I've just talked about in terms of how we address probation periods are in many respects relevant to the performance review and the annual performance process as a whole. And Abisola is going to talk a bit about what we do when we identify performance concerns, and we talk about or consider what might be causing them. But a really key part here is if a manager and their staff member is having regular conversations as well as a thorough formal appraisal, you've set the right tone for those sorts of conversations to be addressed informally and not via a formal process, or to get partway through a formal process and identify that actually, for instance, there's a disability underlying all of this. So having the performance review conversations as a really key marker in everyone's diaries, and something that they address properly, for want of a better word, it is a really good and really effective part of performance management. There's obviously, we're coming at this today from a performance management angle, but it's a really good opportunity as well to make sure that the employee is thinking about their own personal development and their career development and what they want to get out of this role. And then, as I say, these conversations can be the place where you start to explore what might be causing an issue of poor performance. So moving on to the next slide, there can be, we've put some kind of common themes of what could be the cause for poor performance on the slide. It's a very blunt test, and there will be times when it's not quite the right one. But a key question of what you're trying to get to the bottom of here is it that a staff member can't do something, or is it that they won't do something? And sometimes the can't do is for a reason that you can actually get to the bottom of and address. The final slide on key considerations is a lot of information, and I think it's a good idea that you look at this after the session, have a real think about all of these. These are things to bear in mind, particularly when you and a manager are starting to look at what the next step is for addressing a performance concern, making sure that you're being consistent, complying with policies, and understanding how you're going to go forward and address this, and any underlying issues that have been identified. With all of that in mind, I'm going to hand over to Abisola, who's going to talk about dealing with barriers to performance.
Thanks, Samantha. So as Samantha's already identified, there are potentially a number of issues which may feed into poor performance, and depending on what the nature of the issue is, that's likely going to impact on how you seek to address those and the procedure that you utilise going forward. Samantha's already touched on potential personal issues as a reason for poor performance, and that's certainly something that we find that we advise clients on, where a poor performance issue is raised with an employee and they may say that there's a specific personal issue which is impacting on their performance. Clearly, that can cover a range of different things. It could be something relatively short term, such as a house move. It could be something longer term and more significant, such as a bereavement or other personal circumstances. And your approach to this is likely to depend on how long that issue is likely to persist for. In any circumstance, it's likely to be appropriate to offer support to that employee in the normal way through the employee assistance programme, for example, and other support that the institution might have available. But insofar as how you deal with it in terms of the performance concerns specifically, if the issue is of a relatively short-term nature, so for example, a house move is causing disruption in an employee's personal life, but that's likely to be resolved in the next few weeks, it's unlikely to say, well, we're going to formally deal with this as a performance concern and progress it. If you've got reasonable basis to think that that's a relatively short-term issue that you can treat as a mitigating factor, then after that issue has been overcome, seek to address performance in the normal way if it hasn't improved. If it's a concern of a longer term nature, then whilst you're still likely to offer support and support the employee through that issue, it may well be appropriate to treat it as a formal performance concern in line with the procedures that we'll discuss a little bit later, notwithstanding that there is a personal issue which is causing, or at least part of a contributing factor towards the performance concern. The second point that we've popped on the slide is ill health. And I think that that's perhaps one of the most common, but also most complex potential root causes of performance concerns. And that's because of the potential involvement of the Equality Act and disability discrimination considerations, which I'll come on to in a moment. Now, at the outset of an employee identifying that there may be an ill health concern that's impacting on their performance, or even you as an employer identifying that there's a health concern that you think might be impacting on performance, then as well as discussing that with the employee to understand their perspective of how it impacts on their performance and considerations that they think that you as the employer should take into account, it may also be appropriate to seek, or it's likely to be appropriate to seek medical advice through occupational health, potentially through the employee's consultant if they've got one, so that you can understand the diagnosis, the prognosis, and specifically how that concern impacts on the employee's ability to carry out their role. In those circumstances, you're then likely to have enough information to assess whether or not the condition is likely to meet the definition of a disability under the Equality Act. And if it does, then there are then additional considerations that you're going to need to bear in mind, as we've popped on the last part of the slide. Firstly, if the condition's a disability and that has that puts them at a substantial disadvantage in terms of their role, then the institution is going to be under a duty to consider whether there are any adjustments that it would be reasonable to make to try and overcome that disadvantage. And the other consideration that's key here is that the employee will also have protection against discrimination arising from disability and indirect discrimination, which means that the institution is going to have to be able to objectively justify decisions that it takes under its performance management process. So broadly speaking, that's a case of being able to evidence the institutional impact of the poor performance and balance that as against the impact on the employee of their health concern, and make sure that any action that you take is proportionate in the light of that balancing exercise. We've just put a couple of examples on the slide just to show how health concerns may well impact on an employee's performance. In the first example, it talks about an employee's poor performance during a client presentation and how that might be impacted on by their MS. In the second example, it talks about an employee's inability to meet short deadlines and how that may be impacted on by Asperger's syndrome. In both of those situations, it would depend on the specific circumstances, but it may well be that those conditions are disabilities under the Equality Act. So that will require the employer to consider whether there are any adjustments that it would be reasonable to make in the circumstances, and then also making sure that you've got clear evidence of what the impact is of the performance concern on the institution. Is it that client presentations are a key part of that employee's role, and failure to perform to the correct standard may lead to a loss of a potential stream of revenue for the institution? Is a need to comply with short deadlines a necessary part of the role, unavoidable, and something which again can lead to potential adverse consequences? And if so, it may be proportionate to take performance management action in response to that.
And what we've been talking about so far, and Abisola in particular, is understanding a lot about how an employee's performance is A, going, and B, being impacted by things that may be outside of their control. And therefore, a really key part of this is making sure that managers understand what their role is. And I know that institution to institution, the perception certainly can vary. However, it is important that managers are, at the very least, a very, very significant part of performance management. And depending on your institution's culture, may well need to be driving quite a lot of the kind of process. Making sure that this works effectively and that you are working well with your managers is really important. And a key part of that is sharing information with managers and making sure they understand what their role is. So I've talked already about a culture of feedback and making sure that regular performance discussions are productive and are happening. Making sure that your managers understand that and understand the institution's expectations there is a key part of making sure that performance is dealt with at the right stage and an early stage, ideally. Training and development for your managers is really important to give them the confidence to have those discussions, also to understand where they need to be aware of certain issues and to come to HR for support. So that might be, for instance, understanding the rudiments of disability-related obligations. There will be plenty of institutions that do some form of unconscious bias or other equalities training to make sure that they're not unintentionally treating employees differently or not taking into account differences when they're addressing performance issues that might have arisen. And obviously difficult in the current climate, we know that there's a lot of time pressure and financial pressure on universities, which is why performance management is at the fore of many of our clients' minds at the moment as a good way of supporting that. But making sure that, so far as possible, managers have sufficient time and resources to address performance, and actually helping them to understand that is time well spent, that putting those performance meetings in the diary, putting reminders about end of probation periods is a really good way of making sure that in the long term they have a team that's performing well and efficiently. It is a really key part of supporting managers in any performance conversations they need to be having. And equally as a way of making sure that things run as smoothly as possible, and when we do reach performance management on a formal stage, ensuring that everybody understands the timelines we're working to. Actually, we'd recommend that managers have not only access to policies and procedures, but really do understand how they work, so that we don't have a period of, going through stage one, manager gets to the end of stage one, they email HR to ask what happens next. Might, for instance, reach an out of office and a couple of weeks go down the track before anything else further can happen. And that can happen at any stage if there's not a pre-understood plan of how your systems and policies work. So making sure that managers kind of understand what your processes are is a really key way of making sure that any performance that needs to be addressed is addressed efficiently and with confidence by your managers.
Thanks, Samantha. So we've spoken through quite a lot of the considerations that may surround how you as an institution deal with poor performance. And we're now going to look at the procedure that you might follow in doing that. Now, I anticipate that the vast majority, if not all of you, will be at institutions where you've got well-thumbed performance management procedures, which have been in place for a long time, likely agreed with or at least consulted on with the trade unions. I suppose a quick comment that I would make is that in my experience, sometimes institutions can have fairly historic performance management processes, which are slightly unwieldy to follow or slightly cumbersome and can take quite a long time to get to a conclusion point if that's where it's heading towards. So I think in the light of the points that Samantha's mentioned around, there is a lot of increased pressure in the sector at the moment. And I think in terms of what we're seeing, there is certainly perhaps an increased pressure to look at performance for all of the reasons that Samantha has mentioned. It may well be a good time to review your performance management policies if they've not been looked at for a while. Do they allow you to deal with performance concerns fairly, but also in an efficient way, which is effective to deal with? So that may be a takeaway point from today. But moving on, and before we look at the specific procedure you may follow in addressing performance, I just wanted to mention briefly that the sort of unfair dismissal considerations in dealing with capability. Now, as Samantha's already said, in any case where you are dealing with a poor performance concern, the ideal scenario and what you'll be aiming for is to address and resolve the performance concern such that dismissal isn't necessary. But there will be cases in which, despite best efforts by both the institution and the individual, performance just doesn't improve to a satisfactory level, and it therefore is appropriate to consider dismissal. And in those circumstances, you'll want to have considered and dealt with the performance concerns in such a way that you mitigate the risks of a successful unfair dismissal claim if that happens. Now, I don't plan to go into all of this in too much detail because I'm sure you'll all be familiar with the basic principles, but you'll know that capability, including poor performance, is a potentially fair reason for dismissal, but that in order to fairly dismiss for poor performance, as well as having that reason, you will also need to follow a fair procedure. What an employment tribunal would expect is that you follow your written and published performance management policy and also follow the basic principles of fairness. Now, I'd expect those principles to be incorporated into your policy and procedure, But broadly speaking, it's about giving an employee notice of what the shortcomings and concerns are, exploring any underlying reasons for that, as we've already discussed, looking at any support and training that might be necessary to be put in place for that employee, and then giving them a fair opportunity to improve with measurable and objective targets for improvement during a set period, and fair warning that if the performance doesn't improve, that will lead to, for example, a written warning or ultimately dismissal. And then the final point on the slides is just to note that as well as having your performance management policy in one hand, you'll also want to have reference to the ACAS code on disciplinary and grievance procedures. The reason for the question mark is that we're sometimes asked whether the ACAS code applies to poor performance management, but in this context, disciplinary does refer to both conduct and poor performance. So you'll also want to bear the ACAS code in mind. So turning to look at what a appropriate performance management process may look like. Now, the key point is that you will need to follow whatever policy and procedure is set out in your written document. What we've set out here is really just our expectation of what that's likely to look like by way as a sort of reminder of the key points that you'll want to hit in dealing with that. You'll ideally be dealing with the performance concerns informally in the first instance, with a focus on improvement rather than sort of sanction at that stage. So looking at the various points that we've identified on the slide, and which I mentioned a moment ago, are all key principles of making sure that any ultimate dismissal is fair. So identifying the reasons for the shortcomings, what those are, what action plan you're going to put in place, and setting a review period for that. And whilst you won't be issuing any formal warnings at this stage, it is, of course, best practice to confirm any steps that have been agreed in review period by email, so that you've got a written record of what's been agreed. In the event that that doesn't lead to a satisfactory improvement in performance, then you're likely to engage in a sort of process that we've outlined in the slide. Again, it's going to be very much subject to what your written procedure says, but generally we see a process of perhaps 2 written warnings, so first written warning and a final written warning, and then consideration of dismissal if performance doesn't improve to a satisfactory level. At all of those stages, the employee would have the right to be accompanied, there'd be a right of appeal, and at the stages where you're issuing a formal warning, then we'd expect to see a performance improvement plan issued, which will set out what improvement the employee is expected to attain, and the review period over which that's going to be looked at. And then, bearing all of that in mind, I think that makes it sound like a fairly straightforward process, but there are, of course, some curveballs and common issues that we come across in advising that we've just outlined on the slide by way of consideration of how to manage or avoid them. The first couple of points are really around circumstances where you may have an employee whose performance hasn't been satisfactory for quite a period of time. So perhaps that hasn't been picked up during probation, as Samantha mentioned, and it's been allowed to sort of persist for quite a long period. Or even that the institution is just deciding to sort of be clear as to its expectations as to what may have been previously tolerated, but what it's looking to seek to formally deal with at this stage. And that can sometimes lead to unrealistic expectations as to how quickly it can be dealt with. In most cases, it is going to be appropriate to start at the outset of your performance management procedure, even if the concerns are long-standing. And that's really because of the point I mentioned earlier, which is that a tribunal will expect that the employee will have been given a number of opportunities to improve. So I think it's just a helpful reminder that really, as soon as performance concerns are identified, it's worth dealing with them at that stage to allow you to progress through the procedure as may be appropriate. The third point on the slide refers to a situation where there may well be an improvement in performance in line with a performance improvement plan, but the performance may then lapse after that stage, and we do sometimes see that happen. I think the important point there is around the careful phrasing of warning letters. So it may be said that an employee has passed their performance improvement plan, but if the warning makes clear that it's to be in place for a period of, say, 6 months or 12 months, that may allow you to re-enter the performance management process at the current stage if the performance lapses, rather than having to go back to the beginning. So that's worth bearing in mind in terms of the wording of any warning letters, again, subject to your policy and procedure. And then the penultimate point on the slide, again, is a common point that we come across, which is where either during the performance management process or in response to it, an employee has a period of sickness absence, perhaps for stress or a similar condition. And the way in which that's appropriately dealt with will depend on the circumstances, but it's likely to be appropriate to pause the performance review period at that stage rather than allow it to continue while the employee's off sick. Because, of course, you can't review performance while someone's not at work. And it may be appropriate to then switch in dealing with the absence under your absence and attendance management procedure, and then resuming performance management if and when they come back. But then, of course, you're going to have to look at all of the considerations in terms of ill health that I mentioned a bit earlier. And then the final point on this slide is where an employee may raise a grievance during the course of a performance management process. And again, that will very much depend on the circumstances as to how it's appropriate to deal with it. In some cases, the grievance is effectively a response to the performance concerns and can appropriately be dealt with within that procedure. So either as representations against the performance concerns or as an appeal against a formal warning. If the grievance is more serious in nature or unconnected with the performance concerns, then it may be appropriate to pause the performance management process and hear the grievance in the usual way. And then just briefly, we've noted on the slide some of the legal considerations that you'll have in the back of your mind as you're dealing with poor performance. I've already spoken about unfair dismissal and ways in which to mitigate the risks of a successful claim for that. We've also spoken about the fact that currently there's a 2-year qualifying period of service that's needed to bring a claim for that. But we may well see claims for unfair dismissal, or in fact, I think we're likely to see claims for unfair dismissal increase when that qualifying period of service goes away as a result of the Employment Rights Bill. And then we've also spoken about potential discrimination claims which may arise in a disability discrimination context. But the other point that I'd make there is one about consistency, which is that sometimes what we see happen is that an institution may well be fairly dealing with a concern about poor performance, but that employee may have evidence that they have colleagues who are performing to the same or a similar level in circumstances where the only real difference that they can see is that their comparator colleague is of a different race or a different sex, for example, such that they allege that that's an act of discrimination. So in those cases, it is important to make sure that performance concerns are treated and dealt with consistently within the organisation to mitigate against the risk of concerns of that nature being raised. That's particularly because, as you'll know, claims for discrimination don't have any qualifying period of service, so can be more readily brought, and there's no cap on the potential compensation that can be awarded, unlike in an unfair dismissal claim. So again, bearing in mind the disability, discrimination considerations and consistency points is important. So those were all of the points that Samantha and I wanted to cover. So thank you very much for attending. We hope that you found this session useful. I'm conscious that it's now just beyond past, and some of you may have other meetings to go to, so please do feel free to drop off if you need to. But Samantha and I are going to stay on the line for another 10 minutes or so just to answer any questions that you've got. So please do feel free to pop those in the chat box. I should say they're anonymous, so feel free to ask anything, and Samantha and I will do our best to address them in the time we've got. So Samantha, is there anything that you want to pick up?
Yes, there's one question that's come in, well, a couple about timescales. I'll start with the first. How long is it acceptable to wait from informal discussions to formal management of performance? And the answer may not surprise you because we've spoken a lot today about things being fact specific. My answer is that it is going to be quite fact specific, with one major caveat, which is that I'm aware that some institutions do have policies that are quite clear about how long an informal review period should be, and in some ways that informal period starts to look quite formal when your policy is clearly saying it needs to be a certain amount of time with a smart, a performance process with smart targets. However, even if you don't have something of that nature in your policy, I think what you should really be bearing in mind when you're at that informal stage are a few different things. One is, are we confident that we've understood what the root causes of this performance issue are? Because it can be very difficult if you start a formal process only to discover that there are background issues you weren't aware of and would like to address first, such as disability issues or or as Abisola has talked through, potentially just a short-term personal issue. And then also, I think another key point is the scale of the performance issues and how reasonable it is, how long a period it's reasonable to give an employee before you determine that actually you've not seen any improvement yet and it's time to start on a formal process. And a lot of this really is about what's fair to the employee and what's the right period of time before you determine that it is time to look at something more formal. So that will be quite fact specific to the role and to the employee. Abisola, I don't know if you wanted to add anything to that, but I think it is often quite fact specific.
Yeah, I completely agree. And often depending very much on the nature of the specific performance concern as well, isn't it? Because, you know, some performance concerns, an employee will have regular opportunity to demonstrate their improvement or otherwise against that within a relatively short period because it's something they do on a daily basis. Sometimes we find that the practical difficulty is that the concern is something that only arises, say, you know, once every quarter, which makes it harder to give that employee an opportunity to improve during a shorter period of time. So yeah, I'd absolutely agree with that, Samantha. There's a question here which is around, so the question is, for cases where the individual is under investigation for gross misconduct, can a dismissal be a possible outcome if the allegations are upheld and if they haven't had a written warning? And I anticipate that may have arisen from me talking about the expectation that an employee will have a number of warnings before any dismissal. But the short answer to the question is yes. So I think the first point to note is that if we're talking about gross misconduct, that's usually a conduct issue rather than a performance issue. So that's usually something that the institution would be addressing through its disciplinary procedure rather than its performance management procedure. And I'd very much expect, and the general principle is that an allegation of gross misconduct, if upheld, very much is something for which the outcome is likely to be, or certainly could be, dismissal without any previous warnings. I guess this question does highlight the point that sometimes there can be a bit of a crossover between sort of is, and it's a point that Samantha made around, is it a sort of can't do or won't do? So sometimes there may be a slight question mark as to whether something is conduct or whether it's capability and performance. And you'll need to consider in each case what the appropriate procedure is. Most performance, or certainly most sort of recent performance procedures, do tend to say that if the performance concern effectively amounts to gross negligence or something like that, then it may be appropriate to go straight to the potential dismissal stage. So even if it's a performance concern, there may be circumstances where it's appropriate to dismiss without previous warnings. But what I'd say is that those circumstances tend to be quite rare, and it's certainly something that we'd probably suggest seeking advice on before doing so, because the normal expectation is that unless it's a gross misconduct issue, that there would be previous warnings before moving to dismissal. Samantha, anything you want to pick up from the question box?
Yes, there are a couple relating to disability-related issues. So one, can a person raise an unfair dismissal claim without service? And I think there you mean without the 2 year service that is currently the threshold, if the reason is associated with disability discrimination. The answer, I suppose, strictly speaking, is no, they wouldn't bring an unfair dismissal claim. But in reality, they'd have a claim for their dismissal. They would just do it by way of a disability discrimination claim. So the difference Abisola has talked about already in a disability discrimination claim, the key difference is that there is no cap on damages. Now, our compensation in the Employment Tribunal is largely based on the losses that the employee has suffered. And therefore, a really key issue in compensation is whether or not the employee has found a new role or can reasonably be expected to find a new role on what timeline that can be expected. But the difference, the really key difference in a disability discrimination claim is that that cap on compensation doesn't exist. But yes, a disability discrimination claim could be about the fact that the employee has been dismissed. It's just a different legal route for bringing a complaint about the reason for dismissal. And then secondly, somebody has asked if an employee has a disability covered by the Equality Act, but is refusing to engage with occupational health to help aid reasonable adjustments, what route can be taken without medical advice from occupational health? those circumstances do happen. They are quite difficult to navigate. We generally advise that you take advice, but the ultimate issue is you can really only act on the information that you have available, having tried reasonably to get the information that you need in order to make decisions. So you do need to work with the employee as much as you can, but if they won't let you work with occupational health, then it's a question of engaging with the employee and seeing what information you can get hold of before you make any decisions. Quite often you will find that there can be adjustments agreed simply by speaking to the employee, or perhaps they'll give you some medical records, but you can't force an employee's agreement to an occupational health referral.
A question which is sort of similar in nature, but which isn't related to health, is around, but again, it kind of addresses this point around an employee potentially not cooperating with the process, is where, so someone's asked, what approach can you use if an employee refuses to attend a meeting to discuss the concerns and performance plan? And again, that is something that we come across. I mean, I think in the first instance, you would need to understand the employee stated reasons for failing to do that. Is it because they're saying that, that their manager is behaving inappropriately towards them? Is there a sort of valid concern there, or is it simply that they fail to agree that there are any performance concerns and are therefore refusing to engage with the process? Depending on the reasons for it, it may be appropriate to indicate that you're going to have to consider the concerns based on the information that you've got available without the employee's input. I think that's slightly harder in a performance case than it is in, for example, a disciplinary case where you've got an investigation and information to go off. But I think it certainly could be fair to do that if the employee is refusing to participate and they haven't got a good reason for doing that. In some situations, it may be that actually, again, if it's just an outright refusal, it's appropriate to treat that as a disciplinary concern. I think it really will depend on the individual circumstances, but I think the short and the practical answer is that I certainly don't think that stops you from dealing with the issue. It's certainly not the case that if the employee says, well, I'm not going to, I don't agree with this process and therefore I'm not going to participate, that you therefore just have to leave it. There will be a way to sort of progress through it. Either, as I say, based on the information that you've got available, or treating that refusal in itself as a disciplinary issue. But it will really depend on the circumstances.
Right. I started answering the first question saying that there were two questions related to time limits. So I will answer my last question by dealing with the second one relating to time limits, which is, have you got any advice on what a reasonable review period would look like? We use 8 weeks in our policy, which often feels too long. And it is, as Abisola has said a couple of times, it is going to be important that if you've agreed something and put something in your policy, you're generally expected to, by a tribunal certainly, to keep to that. So if that's what your policy says, and if that's what your policy says, it's likely to need to remain unless you do go through the process of changing your policy, which may involve speaking to your unions. I think 8 weeks is reasonably common for us to see as a review period, because as we've discussed in terms of the moving from informal to formal process, it will often be quite specific to how long a period is reasonable to expect an employee to demonstrate improvement. And we're aware that there are roles where somebody performs the same tasks day in, day out. There are other roles and parts of a person's role where it might be less common. So 8 weeks is often a good time period for making sure that you've caught a number of different tasks or duties that might come on a less regular basis, as well as just allowing for peaks and lulls in work. And of course, if holidays fall in a certain way, you might end up extending a period anyway, but 8 weeks is a good starting point. I think so far as universities in particular and educational institutions are concerned, because you tend to have quite formal processes, you are more likely to have a written period, and that's set, and 8 weeks I think is reasonably standard in that respect. But obviously could have something shorter, but you've got to make sure that you have provided enough time for the employee to evidence improvement or an attempt at it.
Great, and then I'll just pick up one final question before we end the session, and again it sort of links to the point that Samantha was just talking about in terms of expectation of following procedure. And the question is it reasonable for an employer not to have a standalone performance management procedure as issues of poor performance forms part of the organisation's disciplinary procedure? And I certainly have come across institutions previously who do wrap up both performance and conduct in the same procedure, and that is the disciplinary procedure. It is certainly a permissible way of dealing with it. And as I say, I think perhaps past practice used to be more that was the case. Personally, my preference is that they're contained within separate procedures because I think the focus is different. The disciplinary procedure is looking at potentially punitive measures as a result of conduct, whereas the emphasis of performance management, for all the reasons we've already spoken about today, is around improvement of performance. So sometimes the language doesn't necessarily sit quite right in terms of having them both housed within the same procedure. It's possible, but I think more complicated. So I think if you've got the opportunity to separate them out, I'd probably advise doing so. But if not, it's a case of making sure that this disciplinary procedure you've got is appropriately framed to deal with both cases, and that I suppose managers don't get sort of strayed into dealing with performance concerns in the same way that they would a disciplinary concern in terms of sort of the language used and, as I say, the more punitive approach. So I think those are all the questions that we've got time for today. So thanks again for coming. As Samantha mentioned, if you could fill out the feedback form that will pop up after this session, we'd be really grateful. Any ideas for future sessions or feedback on this session would be very gratefully received. And we hope you enjoy the rest of your day.